Good afternoon, everyone, and welcome to today's webinar on job support and managing redundancy. We're delighted to have you here with us virtually. Today, our panel will talk you through how to fairly and properly manage the redundancy process during these unusual times. On our panel today, we are joined by Laura Chalkley, Solicitor and Head of Team at Ellis Whittam. We're also joined by Andrew Eldred, ECA's Director of Employment and Skills. I will shortly hand over to Andrew, who will kick off today's webinar by discussing new UK government job support schemes, which come into effect soon. At the end of the presentation, there will be a Q&A session. You can submit a question at any time using the questions panel on your screen now. I will see those and then field them to our panel for discussion later on. A full replay of today's session will be available for playback on ECA's YouTube channel. That's at youtube.com/ECA Live. And for more information on the job support schemes and business recovery guidance, ECA has a dedicated webpage at eca.co.uk/business-recovery. And without further ado, I will now hand over to Andrew.
Thank you, Omar, and hello everybody to a lunchtime webinar. Can you go to the next slide, please, Omar? Lunchtime webinar on job support and managing redundancy. I can't promise you a three-course meal, but in terms of a bit of a starter, as Omar says, we're going to talk a little bit about the job support schemes, specifically the job support scheme for employees, which takes effect from the 1st of November. Then it's the main course, the main event, with Laura talking about the managing redundancy process. And then a little maybe coffee and chocolate from me, just an update on alternatives to redundancy and some other developments that might be of interest to you, particularly if you're JIB members. And then we'll have the Q&A, as Omar suggested. Okay, next slide, please, Omar. Okay, I mean, what this does is tries to encapsulate, give you an overview and a bit of a chronology about what we're dealing with now, because with all these different schemes and acronyms, it can be a bit confusing. I certainly do get confused sometimes. I mean, in terms of what the UK government is doing, this really covers all employees and the self-employed. As we know, we've had it since March, the job retention scheme, otherwise known as furlough, that runs out on the 31st of October. In fact, today is the day when the next sort of change to that scheme takes place, with the reduction, further reduction of the government grant for those on furlough or flexible furlough, and the increase in the employer contribution. Remember also, for those who have been furloughed and have come back from furlough, there will be the opportunity to claim a job retention bonus at the end of January, provided, of course, that they're still in employment. And then, and this is what I'm going to talk about a little bit now, the new job support scheme, which starts in November and runs through to the end of April. For the self-employed, I'm not going to go in detail about the self-employed scheme, but it effectively mirrors what's going to happen with the transition to the job support scheme. In other words, the self-employment income support scheme stays, but it becomes a lot less generous. So from November onwards, for the self-employed looking to claim for a 3-month period, the government grant in those circumstances is 20% of profits up to £1,875 for the 3-month period. That compares with the current level of the grant of 70% of profits up to £6,570 for 3 months. So you can see the direction of travel there for the self-employed, and you'll see also that that's very much the direction of travel that we're going to with the new job support scheme for employees. Those are the UK schemes. In terms of apprentices, you then get into additional arrangements which are controlled by the different devolved authorities, and different parts of the UK have got different arrangements. You'll see that a lot of those jurisdictions, it's really about incentives for taking on new apprentices. or taking on or redeploying apprentices, taking on apprentices who've been made redundant by another employer. Those are the incentives. Interestingly, in Northern Ireland, the incentive also applies to employers who retain existing apprentices. So not merely incentivising recruiting new apprentices or taking on a redeployed apprentice, but actually retaining your existing apprentices. But that is available only in Northern Ireland. Next slide, please, Omar. So onto the job retention scheme. What we know so far, we don't know everything. It was only announced last week, and we've just got a 3 or 4 page document, the link to which you'll see there. Fuller guidance promised shortly, although we haven't had it yet. I mean, we're still waiting for the detail. I'll talk a little bit later about plans to do another webinar when we've got the full detail. But I think in what you're going to hear now, you'll get the gist. You'll get the gist. Okay, next slide, please, Omar. So what I've done in the next 3 slides is try and look at the job support scheme as it relates to furlough, because we're familiar with furlough, we understand furlough, we've lived with it for some time. This first slide really sets out what the good news is. There is some good news about the job support scheme, which is that those cut-off dates that existed for the furlough scheme, the job support scheme effectively wipes the slate clean. So the cut-off date that furlough could only apply to employees on your payroll by a certain date in February, the cut-off date that people couldn't be furloughed if they hadn't been furloughed before by the middle of June, all that is gone. The new job support scheme will be available for any employee on your payroll and reported to the Revenue and Customs on or before the 23rd of September, and they do not have to be somebody who's previously been furloughed. So that's the good news, that's the positive. If you go to the next slide, Omar. On the negative side of the ledger, in making the comparison with furlough, is that, as you'll be aware, with the job support scheme, it is intended only for jobs which are deemed by the government to be viable. And what that means in practice is that the employee needs to carry on working or start working at least 1/3 of their usual hours. Obviously, that compares with furlough, where the employee wasn't working at all, and flexible furlough, where really it was flexible. It was anything from just above 0 up. The other aspect of this is that the government will be looking at that minimum threshold again at the end of January. So it's perfectly possible that threshold could increase at that time. The other element of this, obviously, is that the government grant for the job support scheme is substantially lower. So that's obviously the government grant that covers the non-working portion of somebody's earnings. And as you see, what's on offer for the non-working portion is that the government will contribute up to 1/3, and that's capped at just under £700 a month. That compares to furlough and flexible furlough, where the government was contributing 60%, up to 60%, with a cap of £1,875 per month. So the level of the grant, the level of the government contribution is significantly lower. Next slide, please, furlough. Please, Omar, sorry. Last appearance there by furlough. In terms, obviously, then, if the government element is significantly lower, effectively it's for the employer to make up the difference. So in terms of working hours, it's no change, it's status quo. The employer is still expected to pay all the wages plus pension, national insurance contributions and other costs for those that period for which the individual works. So 1/3 of their normal time or more, depending upon the particular situation. And then for the non-working portion, for the non-working hours, the employer must again contribute 1/3, which is contrasts with 20% under the existing arrangements for furlough, flexible furlough. That final bullet point on the slide just picks out one other area, and I don't know, I mean, Laura might comment on this later, but I think there's an ambiguity here, is in circumstances where the government grant reaches its maximum. So we're really talking here about people earning £36,000 a year or more. The government grant will then cap out. The government grant of a third of somebody's non-working time. That caps out, as I said, just under £700 a month. But the employee, according to the current guidance, is still entitled to 77–78% of their earnings. Does that mean, therefore, that the employer has to go beyond the contribution that I've already set out to make up the difference? I don't know on the basis of the guidance that we've got at the moment. I guess when the detail comes out, we'll know that. It's only really relevant for higher paid people, but certainly something to consider. Next slide, please, Omar. And this really is the final slide, and I'm just going to leave you to absorb that at the moment. This appears in the government guidance, and it tries to identify, encapsulate, if you like, how the system works depending on different levels of hours for employees working and the degree of contribution that the government will make and the employer will make. You might be confused by 22%. After all, I've been talking about a third, which when I last looked was 33%. And Rishi Sunak talked in terms of the third. Just to explain, 22%, that is 2/3 that is a third of 2/3. Effectively, 22% is the equivalent of a third of the non-working portion for somebody who is working 33% of the time. The important thing, though, as you see, as the amount of hours worked increases, the proportion of hours worked increases, the government grant reduces as a total share of the overall earnings that the employee gets, reduces down from 22% through down to the bottom. And of course, you'll see by the same token, the employer contribution increases. So at the employee just working a third of the time, the employer contribution is the equivalent to 55% of their normal wages, and that increases as the amount of working time increases. I mean, the main thing from an employer point of view, particularly if you are a smaller employer, is the difference between the employer cost at the bottom and the hours worked at the top. So effectively, you're getting a certain amount of time, of productive time effectively, but you are paying the difference as set out on the table. So I think that probably for most employers is the calculation that they're going to have to think about and decide about. Is it worth my while to effectively be paying for hours that where I'm not getting production? Now that might make sense if you're looking to tie somebody over for a short period. It might make sense where you're concerned about high redundancy costs. It might make sense where it's feasible for somebody to work part-time. Now that might apply to some of your people, but not to all of your people. But that essentially, that table encapsulates the sort of calculation and the decision that you're going to have to make. Okay, that's my last slide for now. I'm going to hand over to Laura now to talk about redundancy.
Thanks, Andrew, and welcome everyone today. Just by way of introduction, I'm a solicitor and head of team for the Employment Law Membership Advisory Services at Ellis Whittam. And for today's session, we're going to dedicate it to discussing managing redundancy. If we just move on to the next slide, what I've set out there is a sort of brief overview of what we're going to look at today. So firstly, we'll discuss the importance of the business case. So what amounts to redundancy situation in the eyes of the law, before covering when the obligation to collectively consult may be triggered. Then I'll talk about volunteers for redundancy before moving on to discuss pools for selection and selection criteria. We'll then talk a little about alternatives to selection, including competitive interview processes. And finally, I'll cover the requirements to look for alternative employment and end by discussing redundancy pay. And most people will find redundancy situations the most difficult kind of issues to deal with. There's a number of moving parts, and I'm sure that it can feel quite overwhelming at times to deal with, especially when you've got all your ongoing business pressures as well. So what I hope to do today is to give you some confidence in how to deal with these sorts of issues, and hopefully some insight into the sorts of things a tribunal will look at when considering whether you've handled the situation correctly. Indeed, what I'll do is focus mainly on the 5 topic areas that a tribunal would focus on. So whether there is a genuine redundancy situation, consultation, pooling, selection criteria, and alternative employment. If you get those 5 right, you'll go a long way towards satisfying the tribunal that any redundancy dismissals were fair, because let's be honest, the last thing you need when you've gone through this kind of process, you've got the challenges of your business, is a tribunal claim on your hands to follow. I'm just going to make brief reference here to those of you who are maybe JIB members. The interesting point is that JIB employees are entitled from day one of their employment to appeal to the JIB against an allegedly unfair dismissal, and that right includes redundancy dismissals. It is referenced in the JIB handbook, so just something to be mindful of there if you are members. So if we can just move on to the next slide, please, we'll have a look at the business case, so starting at the very beginning. In every redundancy situation, we'll start with a plan, and it makes sense to set this out, not least for your own purposes. You'll need to think about why the redundancies are necessary. What alternatives are being considered or implemented? How many redundancies will you need? Where will they come from? How will people be selected? And what's going to be your timetable? Many of these points may well be flexible, and as part of a proper consultation process may be liable to change following discussion with employees. So you may need to prepare yourself to be a bit flexible in your timeframes and your plan. However, what you always want to start with is some kind of plan of what you're trying to achieve and why. As employment lawyers, we'll often ask for copies of the rationale or making sure clients have a robust business case. It's always wise to understand what your business is trying to achieve, but at the same time, you need to be aware of the limits of the tribunal. Generally, an employment tribunal will not look behind the decision to make redundancies. It's not their function to tell you how to run your business or judge whether or not the decision to make redundancies was commercially sound. If there's a reduction in the number of employees carrying out particular work, a particular kind of work, that's enough. The tribunal is more concerned about the process, the consultation, the pooling, the selection criteria, and the search for alternatives. So from that perspective, the business case is important for your own planning requirements, and it's important to help explain things to your workforce. However, it's less important on a purely legal basis. So let's have a look now at when there is a redundancy situation. If we can have a look at the next slide, please. So under the Employment Rights Act, there are 3 situations which qualify as redundancy. Firstly, an employer is ceasing to trade. Secondly, we have a workplace or site closure. And thirdly, a reduction in the requirement for employees to carry out work of a particular kind. To legitimately make someone redundant, you must fall under one of those categories. Now, quite commonly, we see clients trying to use redundancy as the easy way out for a problem employee or someone with performance issues. Unfortunately, that won't work unless the situation also meets the definition of redundancy. A total business closure is pretty self-explanatory and quite straightforward. If a business is due to close completely, perhaps where it's gone to administration or liquidation, or just someone is retiring and closes the business entirely, that will amount to a redundancy situation. In a total employer closure, there's no issue about pooling, selection, or alternative employment, as it's likely that everyone will be made redundant. However, this isn't restricted to just permanent closures, and it will include temporary closures too, which is where it gets a bit more complicated. Perhaps you're closed for, if you have an office space, for example, you have a refurbishment or short-term for financial reasons. That might be caught by this definition of redundancy, but it's very fact dependent, so always worth taking advice if you find yourself in that situation. When it appears that the employer is replacing one business with another, a tribunal may have to decide whether the new business is sufficiently different in nature from the original business to mean that the original business ceased. If it is sufficiently different, the dismissal of the employer's original employees will be for redundancy. Again, whether the businesses are different might be a question of fact, But if a new business opens up shortly afterward, the old one closes, that might not be a redundancy. Finally, in this regard, we also need to be mindful of TUPE. In the context of a business closure, especially one which is brought in pre-pack administration, TUPE will apply and employees will transfer to the new owner rather than being made redundant. And again, if you find yourself in that situation where a business is being bought, worthwhile taking some advice on that to make sure we don't fall foul of a different set of regulations under TUPE. If we can move to the next slide, please. So a site or workplace closure is the second category of redundancy, and again, relatively self-explanatory. If we have an office closed, which where there might be several office sites, and one of them closes, then that's likely to be a redundancy situation. However, one question that often arises in practice is where the employee is actually based and where they work. The settled position at the moment is that the tribunal should largely ignore what the contract says, including any mobility clauses, and instead may look at the reality, the facts of the situation to determine where the employee is actually based and where their workplace is. So when we talk about mobility clauses, we're talking about where there's provision in the contract to for an employee to work from different locations. You may be required to work to site. And this poses an interesting question in these sorts of cases. While they don't really determine where the employee works, they can be used to determine whether or not the employer is faced with a redundancy situation. So if you imagine a situation where you close a premises on the basis that you're building a new premises 2 miles up the road, given that this involves a workplace closure, is it a redundancy situation if the employers have mobility clauses in their contracts which enable you to move them? The answer is probably not, as where there's a mobility clause and there's work available at another location, an employer may choose to invoke that clause instead of dismissing that employee as redundant. A reduction in the requirement for employees to carry out work of a particular kind is by far the most common redundancy situation, and arises where you're looking to reduce a team of people from, say, 10 to 5, or make a unique position redundant. When you're considering this type of redundancy, the starting point is, what are the requirements of the business? This implies a commercial judgment on your part about the priorities of the business and about which kind of work or employee has become surplus to your requirements. You do have a fair degree of latitude here because, as I said earlier, it's not the purpose of the tribunal to tell you how to run your business. Can we move to the next slide, please? So another question we have to look at briefly is whether collective consultation is required. Now, I understand that this will not apply to the majority of those listening, so I just wanted to touch on this to make you aware when it might apply. If you need any further information about collective consultation, this can be found on the ECA website. So on the screen, you'll see the exact statutory definition of when collective consultation is required. And this is where an employer is proposing to dismiss as redundant 20 or more employees at one establishment within a period of 90 days or less. That's when there'll be a requirement to collectively consult. Consultation will be with either a recognised trade union or, in its absence, elected employee representatives. If you're proposing between 20 and 99 redundancies, the consultation must start at least 30 days before the first dismissal. If you're proposing 100 or more dismissals, that period of consultation is 45 days. So whether or not you're required to collectively consult can be broken down to 3 subsections: proposing to dismiss, 20 or more redundancies, and at one establishment. What can constitute an establishment can be a bit of a tricky area, particularly where you've got people working remotely across sites. And whilst we don't have time to go into huge detail about this today, I would strongly advise taking advice where you're looking at making more than 20 redundancies across your business. There are also additional obligations for those of you who are JIB members. Looking at the JIB handbook, the terms aren't entirely clear, but it implies that the JIB should be consulted regardless of the number of redundancies you're looking to make. And certainly Unite the Union would be the relevant representatives with whom you should be consulting for any consultation process. But again, please do seek advice from the ECA advisory service if you find yourself in that situation or you have any further questions about that. So just moving on to the next slide, please, Omar. So when we talk about proposing to dismiss, what does that mean? So this is really about what's in the employer's mind and at what stage is the thought process about regarding redundancies. Proposing is generally held to occur at an earlier stage than the actual decision by the employer to make redundancies. So it's less than a decision to actually make redundancies themselves. If you've already made the decision that redundancies will happen, you're probably too late. At the same time, proposal means more than mere contemplation of the possibility of redundancy dismissals. If you're at this stage, the obligation to collectively consult will not quite be triggered. So really it's somewhere in the middle. It needs to be firmer than simple contemplation, but you shouldn't have already decided that redundancy dismissals will be made. And this can obviously, as you can probably tell, can be quite a difficult distinction to draw. So it's best to start earlier rather than later. So there are two main problems in starting consultation at the wrong time. Either you end up terminating employment before the end of the 30 or 45-day consultation period, which is unlawful, or you start too late and there may be an argument that the consultation was inadequate, since the purpose of it is to explore alternatives and ways to avoid redundancy. If you are too far along to be able to do this meaningfully, there may be a breach, which could also affect the fairness of the dismissals. And my feeling is it's better to start too early, given the purpose of the consultation, which is to explore avoiding redundancies. So can we move to the next slide, please, Omar? So looking at consultation now, quite apart from collective consultation, and regardless of the number of redundancies you're talking about, consultation sits at the heart of every redundancy process. So collective consultation does not eliminate the need for consultation with individual employees, and that is fundamental to the fairness of any dismissal for redundancy. It's also something that should be an ongoing thing every step of the way. So in order for an employer to consult properly, it must have an open mind and still be capable of being influenced about the issues which form the subject matter of the consultation. And that means consultation will only be meaningful if it happens at a formative stage rather than where there's already a fait accompli. And what we're talking about here is consulting about a proposal to make the redundancies in the business case and are there any alternative ideas to avoid that? So this means that the key components listed on the slide must be present. So firstly, start your consultation before the plans have crystallised. And that is why when you have any at risk of redundancy meeting, it's important you talk in non-definitive terms. So in mentioning that these are proposals and asking employees for their input, for example, ways that redundancies can be avoided. That also means you have to give them adequate information on which to respond. So if you remember back, we were talking about our business case and rationale. This is where it becomes more important. So your employees understand what you need to do and why and what your proposals are to achieve that, so they can consult and consider and bring forward any ideas they may have. Time is also very important. So outside of collective consultation, there are no prescribed timetables, but these processes should not be rushed. Now, I'm not suggesting you have to consult for weeks and weeks at a time, but you do have to give people reasonable time to consider what they're being told and to allow them time to respond. And this applies every step of the way. So not only about the redundancy situation overall, but in relation to what selection criteria may be, what their individual scores are, and any alternatives to redundancy. Finally, just another point to add here is that you should not just pay lip service to any responses during consultation from your staff members. Consider what's been said, show that you've taken the time to do that, and if their proposals to avoid redundancy don't work, explain to them why before you move on to the next stage. Can we look at the next slide now, please, Omar? So the matters that should be discussed during the individual consultation process will depend on the specific circumstances. But in terms of a process that will usually involve steps set out on the slide. So firstly, an initial announcement to those at risk, which can usually be done in a group setting, where you will set out the reasons why redundancies are being considered. Rationale in your business case again becomes relevant here to explain or sell the need to make redundancies to your workforce. Unless the pool for selection is really obvious, or we're talking about a pool of one, there should be consultation about the composition of that pool of employees. And that could be as simple as saying, we suggest the pool will be all employees from a particular department or have a particular job title. Consultation on the selection criteria may be more difficult, and often employees will have a view about what should or should not be taken into account when assessing their performance, for example. Once you've done your scoring, you should hold a further meeting with the employee to discuss their scores. And I no doubt they'll have arguments about why they should have scored higher in certain categories, and you'll need to hear this, consider it, and respond. There may be a bit of element of rescoring here if you do accept what the employee is saying. Otherwise, it'll be a case of explaining why the score was given and why you believe it was correct in the first place. Once the scoring is finalised, there should be a final meeting to discuss alternative employment, and in the absence of any, you'll then confirm redundancy and notice. Now, whilst there's no legal obligation to offer an appeal, it's certainly best practice to do so, and something we would recommend in most cases. Just a couple of final points here. If there is a redundancy policy dealing with procedure and consultation, that should of course be followed. The statutory right to be accompanied only applies to attendance at disciplinary and grievance meetings, and not specifically redundancy consultation meetings. However, and again, as a matter of best practice, we would recommend it. And certainly if you have a redundancy process set out in a handbook that requires it, you should certainly follow that. So just moving on to the next slide, we'll have a look at volunteers for redundancy. So something you may have heard about people volunteering, but the first point to make here is that there's no law requiring you to seek voluntary redundancy before you make compulsory redundancies. In addition, a failure to seek volunteers would not make any subsequent process unfair. However, before you start any consultation process, it sometimes makes sense to ask for volunteers. Volunteers may minimise compulsory redundancy, so morale is not impacted as much. Plus, benefit is it can save you lots of time and effort avoiding a drawn-out procedure where there are people who are prepared to put their hand up and be the one to go. To keep control of the process, it makes sense from the start to say that if someone comes forward, you reserve the right to say no to their application for voluntary redundancy. Because the last thing you want is obviously a talent drain, and there'll be some people who are business critical and cannot be spared. In addition, you may get more volunteers than are required, or they may be from the wrong area of the business, so you should make all of that clear from the outset. It makes sense to just have one short meeting with any volunteer to make sure they understand the consequences of their decision before confirming any dismissal. If someone volunteers, the reason for dismissal is still redundancy, so they would be entitled to redundancy and notice pay as usual. So if we can please move to the next slide, we'll have a look now at the pool for selection, where you're looking to reduce the number of people in a particular role or department. So from your business case, you should know by now where in your business you're looking to shed roles. And as a result, you need to consider what the appropriate pool of employees for redundancy selection should be. There are no fixed rules about how the pool should be defined, and unless there is an existing agreement or custom and practice in relation to a selection pool, you do have a fair degree of flexibility in defining it. The main question for the tribunal is whether the choice of pool was within the range of reasonable responses. So where you genuinely apply your mind to the choice of pool, it's going to be difficult for an employee to challenge that. One crucial point, though, is that there's no requirement that a pool should be limited to the employees doing the same or similar work. Often, in a redundancy situation, you're faced with a pool of one person. If that individual is in a unique role, it may not be appropriate or possible to pool them with anyone else. That does make for the rest of the selection exercise more straightforward, so there's no need for any selection criteria, for example. But you do have to check whether the unique role is interchangeable with anyone else. If so, it may be reasonable to pool those two or three or four individuals together. So just something to be mindful of, and be aware if the employee may challenge that if we're just going to speak to them as an individual. So can we move to the next slide, please? So in view of what I've just said, how do we identify the pool for selection? A sensible starting point for drawing up the pool is what the employee actually does, having regard to their day-to-day activities and the terms of their contract. However, we do need to look at the reality of the situation rather than just what the contract says about what the employee may be required to do. And it's important to consider the following questions. What type of work is ceasing or diminishing? Now, this is usually pretty obvious, but don't forget it's the work or role that is diminishing. It's not about individual employees. Which employees are doing similar work, possibly even those other locations? Now, this is really crucial. You have to be careful not to be too narrow in your choice of pool. And the question of the extent to which those other sites or geographical locations should be included can be quite a difficult one. And if in the past employees work or have worked at different sites to cover holidays or sickness, there may be arguments that they should be pooled together because they cover the same area. Geographical proximity is also important, and on a very general level, the closer the sites, the more you'll be required to consider pooling them, those individuals together. We also need to consider which employees' jobs are interchangeable. Identifying a pool is more complicated where employees are multi-skilled and do different types of work, or can be required to do so under their contracts of employment. If roles are interchangeable or where employees have previously done other work, there'll normally be a strong argument that it's reasonable to pool the employees together. Now, this sort of argument is also likely to apply to the so-called low-skilled work, as again, this is more likely to be interchangeable. The last 2 points there, have you genuinely applied your mind to the composition of the pool? And has the selection pool been agreed with the union or employee representatives we've discussed already? If there's an agreed pool or one that's been established through custom and practice, you'll generally need to use that. And again, ask yourself, have you genuinely thought about this? As in thought not only about the pool you've arrived on, but also the alternatives. If you have considered the alternatives and can explain why they won't work along the way, this will go a long way towards persuading a tribunal that the choice of pool was reasonable. And just a quick note here on apprentices. Again, those of you who are JIB members, where a JIB employer wishes to make an apprentice redundant, they are under an obligation to continue employing and paying that apprentice until either an alternative training provider has found another employer for them to move to, or it becomes clear that another employer cannot be found. Now, those are always steps that I recommend doing anyway with apprentices, but it is formalised in the JIB processes to have to do that. So if we can move to the next slide, please, Omar. So we'll now move on to what I think is probably one of the most difficult parts of the process, which is purely on a practical level, and that's the selection criteria. So from a legal perspective, as well as considering the reasonableness of the selection pool, the tribunal will consider whether the selection criteria used by the employer are reasonable. The concept of reasonableness again means that the employers do have some discretion. However, in order to be reasonable, the redundancy selection criteria should, as far as possible, be objective and measurable by reference to evidence rather than just based on managers' personal subjective opinion. That also makes it less difficult to challenge. If you have union involvement, then the post-selection criteria should also be discussed with them at the start of the exercise. And you should also check any redundancy policy you may have in place to see whether there are existing set criteria. In the absence of union involvement or set criteria, the selection criteria are something you'll need to consult your workforce about directly, perhaps by setting out what they're proposed to be and giving them perhaps 48 hours to comment and respond. And that would usually be at the meeting after your initial one where you're placing the roles at risk of redundancy and you've discussed any possible alternatives to redundancy. If it's clear that things are going to have to progress, then that's the point at which we'll talk about the proposed selection criteria. On the slide here, I've set out what potentially fair selection criteria can include. And ideally, you'll be looking at around 4 or 5 criterion, and they'll be objective as possible. You have a wide discretion, so you don't have to obviously use these, but your starting point should probably be to work out what you measure, what's important for you as a business going forward, and then devise it from there. Looking at the criteria I've set out in the slide in turn, performance and ability can often be tricky. It's important an employer chooses clearly defined criteria and a system of weighting that relates to skill and knowledge required for its current and future needs. When you're assessing the performance of each employee, you should refer to written records, which demonstrate the quality or quantity of their work. If you don't have any written performance appraisal absence about quality or quality of work, then your performance appraisals is a good place to start. So this is, again, rather than relying on a manager's personal opinion at the time of the redundancy exercise. It'll be difficult for the employee to challenge the employer's reliance on appraisals, particularly where they've agreed with comments in the appraisal that's already been and gone. So this is a good place to start. Now, length of service traditionally used to be something we use quite a lot of, and it seems to be quite an obvious selection criteria. There is a lot of case law around this. There's last in, first out. And now this should not be used as the only selection criteria, as what it tends to do is penalise younger workers who generally have shorter service. And so what we find is it can be indirectly discriminatory on grounds of age. However, if it's part of a wider 4 or 5 criteria, or sometimes employers will use it as a tie break if you get people with the same level of scores, then it's perfectly acceptable to refer to it then, as long as it's not the only thing you're looking to rely on. An attendance record is another very common and, on the face of it, objective criterion. First, you'll need to make sure that the records are accurate. And in addition, consideration will need to be given as to whether certain periods of absence should be discounted from the scores. So, for example, any absence of a pregnancy-related illness should be discounted. Or if the absence is related to an employee's disability or alongside medical condition, then including that in a scoring exercise could be discriminatory, and the employer might need to make a reasonable adjustment to discount that absence, so they're not unfairly scored as a result. And don't forget, it's also important to consider the period over which the attendance will be assessed. Now, the period should be reasonably substantial, and a year is usually about common, as shorter periods won't provide an accurate picture of attendance. An employee's disciplinary record is another common criteria, but it only really works in a pool where employees are subject to some kind of sanction. We've said disciplinary record here, but if warnings about poor performance have been issued, they could be included as well. And the final point I've just flagged there on the slide is about discriminatory criteria. And we've already mentioned how you need to tread carefully with regard to using last in, first out and attendance, as they can potentially be discriminatory. But you need to keep that in mind when considering all of your criteria about whether someone might feel they've suffered a detriment because of having a protected characteristic. Of course, deciding upon the actual criteria is the most difficult task, but don't forget you have to devise a scoring too. So where are you going to draw the lines for each boundary and then score them? What should someone with a perfect attendance record get compared to someone who's been off 4 times in 12 months? Again, you've got a fair degree of latitude here to draw on your own boundaries, and the obligation again is to act reasonably in that regard. So if we can move to the next slide, please. So what are some of the trickier issues when dealing with selection criteria? In some jobs, such as sales, there'll be a number of readily available targets that can be used to measure performance. However, in other roles, especially those that are lower skilled, records might not exist, or it might not be possible to measure the output of individual employees. Whilst appraisals can be used in this regard, not every company carries out regular appraisals, so what can we do here? In these sorts of cases, assessment of performance may have to involve a subjective analysis of the qualities and skills of the person. Now, this can be done by breaking down performance into subcategories, each of which can be assessed separately by reference to some fairly detailed scoring guidelines. If guidelines are provided, the scoring should ideally be carried out by more than one manager to eliminate the possibility of bias or animosity, and the manager then provides an explanation as to how each score has been arrived. And this will carry weight and go towards reasonableness, where we've got 2 people's scores to measure and can see a sort of fair score was achieved. Second point there is don't forget to consult about the scores. Once you've done the scores, share them with the employee who remains at risk or in the danger zone for selection, so are your bottom scorer or scorers, and give them the opportunity to have a say on the scores they've received. Following individual consultation, some scores, as I mentioned, may need to be amended, and this is simply part of the process. And if an employee has reasonable and compelling grounds for scoring higher, you should adjust that accordingly. Having said that, the employee's ability to challenge their score in tribunal is pretty limited. A tribunal should generally not get involved with the minutiae of how individuals are scored, nor should they rescore employees months down the line. Close scrutiny of the scores isn't appropriate by the tribunal unless there are exceptional circumstances such as bias or obvious mistakes. Instead, the tribunal should focus on whether you have a good system in place for assessing employees against the criteria. So again, explaining how you come about your selection scoring process will be important here. And finally, I just want to touch upon the use of competitive interview process by way of selecting for redundancy, as we're starting to see more of that. In many ways, it's easier for an employer, and case law suggests it's much harder for employees to challenge a tribunal. It certainly works as a method for selection where jobs are changing, so where you've got perhaps a new look job emerging, and you've got a pool of people competing for a new role. However, we've had a recent employment appeal tribunal decision which suggests using it instead of a traditional selection exercise where people are effectively interviewing for their current jobs isn't acceptable. So we would need to have some differentiation in the new jobs going forward. Can we have the next slide, please? So I'm just mindful of time now, so I'll just have a quick look at bumping. So what is it? It may have been something you've heard of, but essentially it's the process of moving a potentially redundant employee A into another role, and then you dismiss the employee who's currently performing that role B. This is still a redundancy dismissal, even where there is no or actual or anticipated diminution in the requirements for the employees to do B's work. It can be used in any redundancy situation where there are other employees who are not at risk of redundancy. And the main question is likely to be, should it be considered and used? There's no general obligation to consider bumping, but in some circumstances it may be unreasonable not to do so. Most cases will turn on the issue of seniority, and there are cases that have found that not considering bumping a more junior employee for a senior person who was at risk of redundancy was unfair. However, we've got some cases going the other way, the typical employment tribunal swinging one way and the other. So what things to consider here are whether or not there's a vacancy, how different the two jobs are, the difference in remuneration between them, the relative length of service between the two employees, and the qualifications of the employee who's at risk of redundancy. And most situations will turn on their own facts. There is a duty to act reasonably in these situations, but again, as I've mentioned, there's no absolute obligation to consider bumping, unless we believe that actually it's appropriate in the situation for us to have considered that, and it would be unreasonable not to. Can we move to the next slide, please, Omar? So a dismissal is likely to be unfair if at the time of the dismissal, the employer didn't give any consideration to whether a suitable alternative employment existed within your business. The duty on the employer is not to make every possible effort to look for alternative employment, but to make reasonable efforts. And as a result, there's no obligation to invent a role where one didn't previously exist. Usually the requirement can be satisfied by sharing a job vacancy list, including details about any pay, with the employees who remain at risk of redundancy, and asking them if they're interested in any of those roles. I tend to take the view that you should leave it up to the employee to decide whether or not they're interested in other roles, rather than making that decision for them. So whilst it's easy to think that someone would not be interested in a very junior or comparatively lower paid position, let them make that call, not you. It may sometimes be appropriate for employers to consider the availability of alternative employment, not only within the particular company in which they're employed, but also if you are part of a group of companies. Now, it's important to note that unreasonable refusal of a reasonable alternative role can sometimes mean that the employee will forfeit their right to redundancy payment, so they won't receive it if we think that what we've offered them is suitable and they say no and they haven't got a reasonable reason for doing that. Now, whether their refusal of that role is unreasonable will turn on the facts. So always take advice before you say we're going to withhold redundancy pay in those situations. It's widely accepted practice that most new roles that differ to the previous position will be subject to a 4-week trial period. Now, the law around statutory trial periods is actually quite complex, and most people are surprised to know that a statutory trial period only applies at the end of a notice period when, and in practice, most trials will take place during or even before the notice period begins to run. Now, regardless of the legal technicalities, it makes sense for the employer and the employee to agree a trial to check that the new role suits both parties. So this is your assessment as to whether that person's suitable for it, and similarly for the employee themselves to decide whether they think it's a suitable alternative to their original role. And if the trial isn't successful, the reason for the employer will go on to be dismissed, and that reason for dismissal will still be redundancy. And finally here, a note on special protection. So if a redundancy situation arises during an employee's maternity leave, and it's not practical by reason of redundancy for the employer to continue to employ them under their existing contract, the employee is entitled to be offered suitable to vacancy where one's available, and to start immediately after her existing contract ends. Effectively, what this means in practice is that the employee on maternity leave gets first refusal of any suitable job available, and this is a rare example of what is essentially positive discrimination in UK employment law. And finally, onto the next slide, just a quick look now at redundancy pay. So employees with 2 years plus service are entitled to statutory redundancy payment, and there is an excellent online calculator at the gov.uk website that will do the calculation for you, provided you've got the employee's start date, age and gross weekly rate of pay. Now, the notion of a week's pay is contained within the Employment Rights Act and is central to what constitutes a statutory redundancy payment. And surprise, surprise, those provisions can be quite complicated. The easy bit first, for all employers, for all employees' employer pension contributions, they should be included in the calculation. So what they state is for employees who work fixed hours for a fixed salary, which is majority of employees, the calculation is pretty straightforward. So a week's pay is simply your normal gross basic salary paid earned in 1 week. If the employee works fixed hours but their salary is variable, a bonus will only form part of a week's pay if they do piecework. And this is important in a sales context. So generally, sales or commission earned based on the quality or quantity of sales made will not be included in the calculation of a week's pay. If the employee doesn't have normal working hours, then generally a week's pay is calculated by taking a 12-week average of all their earnings, including bonuses, overtime and commission. And don't forget, the statutory redundancy pay is capped, and it's currently at £538 per week, but you should always check for more generous contractual entitlements if you have that separate contractual redundancy policy and you promise more than this. Finally, for any, if you have any employees who are on furlough currently and they are ultimately made redundant, a week's pay should be calculated at their normal rate of pay, not the reduced furlough pay. It's something we've had quite a lot of questions about recently. Now, I'm mindful that was a bit of a whistle-stop tour, but I do hope you took some useful pointers from that. Thank you.
Okay, Emma, just go on to the next one, and I'll be quick. If you could go back one slide, please, Emma. I'm not going to be that quick. This slide just is a reminder that there's lots of resources there for you, both on redundancy, including a model redundancy process and procedure, and also the alternatives. Also, there are videos on our YouTube channel, including some past webinars. So quite a lot covering employees in general and apprentices in particular. The one thing I would highlight from this slide is the Lone Labour Scheme. Some of you will be aware of the Lone Labour Scheme, whereby members can share labour between them. Just some data on the Lone Labour Scheme since it was relaunched a couple of months ago. In that time, we've had 22 inquiries covering pretty much every part of the country, including parts of the country which previously hadn't made use of the Lone Labour Scheme. Of those 22 inquiries, 16 were from companies who were looking for labour. 6 were from companies who had labour available. So if you are a company who are contemplating redundancy at the moment, the chances are there is somebody in your ECA region who might be looking for labour. So please, before you do anything else, if you haven't already done it, get in touch with the Lone Labour Scheme to see if you can find a temporary home for people. Next slide, final slide, Omar. Yeah, okay. Quick updates on other stuff. For those of you who are JIB members, you should have received a communication yesterday, if not before, confirming that the employers have said that they can not contemplate increases for next year, so therefore there needs to be a pay freeze. In terms of what's going to happen next, the union are not agreeing with that. They are consulting members at the moment. But the reality of the situation is that unless anything changes, the existing rates will roll over into next year. The only change will be to lodging allowance, which you'll probably be aware is subject to a separate exercise that's negotiated with the Revenue and Customs. So lodge will go up, but unless anything changes, nothing else will. Of course, that begs the question: will anything change? All I can say to you is we've had a clear instruction from our members that they cannot contemplate an increase, and I cannot foresee that position changing. Other updates: employee relations team. Those of you who know Orazio has left us. SNEA is still part of the team, and an even more important part of the team now, and we're currently looking at ways to support SNEA, and we expect to have an announcement about that very shortly. We are going to do another webinar on the joint support, the job support scheme when we get more information, date to be confirmed. We'll probably couple that with something more on apprentices. We've asked JTL if they can come along and talk about a range of issues to do with apprentices at the moment, both the, sort of the training of apprentices and other aspects. So we'll confirm that date shortly. And as always, if in doubt, or if you want, further assistance, there is always the contact number and the email address that you can see in front of you there. That's it for now. I don't know if there are any questions, Omar, but if there are, we've got a minute or so to deal with them.
Thank you, Andrew, and thank you, Laura, as well, for your presentation there. Apologies if we do overrun slightly. Just a quick reminder before we dive into a couple of questions. You will have seen a few links there, a few resources mentioned. All links to those will be included in the description of the YouTube replay. That'll be up on our YouTube channel later on this afternoon, so keep an eye out for that. So I'll dive into a couple of questions from the audience here. We have one. I'll do my best to sum it up. It is fairly lengthy. So there is a small business owner who had to make 3 of his employees redundant at the end of July. He's now left with 2, but looking ahead, it is not promising, he says, and he's bracing himself to make these 2 redundant around the end of October. His question is that he would owe them around £10,000 in redundancy, and if he needs to pay this ASAP, it would possibly lead to the business closing down. Is it possible to stagger these redundancy payments, and is there any support for businesses, for business owners in that position?
So in terms of, obviously the payment, the starting point is the payment is due. Unless the company goes to administration, there is a government pot which employees can go to for redundancy payments in that situation. But if the business is still live, again, discuss with the employee. It can be agreed with them if they're happy. They're only going to try and bring a claim if it's unpaid. So if it won't be worth their while if you set out reasonable arrangements for staggered payments, because it's not worth them bringing the claim because it's on its way to them. So if you can agree it and discuss it with employees, don't see any reason why not.
Thanks, Laura. I'll just go through one more question from the audience before we wrap up. Apologies for overrunning ever so slightly. Is there any flexibility on the date when the redundancy comes into effect once all the correct procedures have been followed?
So usually a business will have an idea of when they need to make it. Say, for example, it depends on the reason for redundancy, I suppose. If it's in terms of making urgent cost savings, then if there's no specific date in mind by which they need to be done, then obviously you need to factor in your notice periods. So once you've gone through your consultation process, the employees will be entitled to notice paid. Now you do have the 2 options there. either the employee works it, and so their last date of employment will tie in with that, or if you feel, no, we need to get the individuals out of the business and start moving forward, then you've got the option to pay them in lieu of notice, so that can bring forward their last date of employment.
Omar,
Right.
Andrew here.
Yes.
If there are any other questions, fire them across to us and we will answer them to the people who've asked the questions, okay?
Will do. And thank you to everyone who submitted a question today. And final thank you to Andrew and Laura for your presentations. We will wrap it up there for today. Thank you all again for joining. And as I mentioned, you can find more resources at eca.co.uk/business-recovery, and also keep an eye out on our YouTube channel for a replay of today's session and replays of all our previous sessions going all the way back to the beginning of the lockdown this year. So thank you everyone, and have a great rest of your day.